One thing that is certain in this life is that one day it will eventually come to an end. Just like a family that prepares for the delivery of a newborn child, death should be treated with a similar level of respect. After all, with the unfortunate demise of a loved one comes the immediate issue of medical and funeral expenses, not to mention the concerns of dependents who may have relied on the deceased for financial support. Without any form of planning, an unforeseen death can prove rather difficult for a family, especially where there is a clash of personalities in the decision-making process. To avoid these issues, it is often wise to consider the drafting of a will to leave your final set of instructions with respect to who is left in charge of your immediate affairs, and if done properly, will remove any doubt on how certain decisions are made. A will is a legal instrument that provides written instructions on how a person's assets are to be distributed after death. In the Bahamas, a valid will must be in writing, signed by the person making it in the presence of two independent witnesses who appoint an executor of sound mind and over the age of 18. There are a number of advantages of having a will, including the ability to decide how your assets will be distributed, who will take care for minor children, and who will wind up the affairs of your estate when you die. Non-residents who are owners of immovable property in the Bahamas may draft a will to accommodate the distribution of their Bahamian assets. Now, I'm sure that many of you have found websites that claim to draft your own personalized will once you provide them with certain information, but I assure you that when it comes to the Bahamas, you will need to retain the services of an attorney who can advise you accordingly and properly draft your will, tailored specifically to your circumstances. A computer-generated template of a will from another country simply cannot provide the particulars needed in order to make your final instructions as effective as it ought to be under Bahamian law. To ensure efficiency with services, you should secure original copies of documents which can demonstrate proof of ownership of your assets, such as bank account information, insurance policies, share certificates, title deeds of property, or an inventory of personal items you wish to distribute. Retaining counsel is also important in cases where a loved one passes without a will, or what we refer to as dying intestate. Under these circumstances, the rules of succession under the country's inheritance laws will apply, which ought to be explained by counsel in order to prevent certain misunderstandings of the law, such as the mistaken belief that children born out of wedlock are excluded from inheriting assets, or that guardianship of minor children are automatically granted to their favorite auntie. Getting proper legal advice would ensure that probate applications are conducted thoroughly and may prompt the drafting of a will before death in order to secure their loved ones and avoid state intervention after an untimely death. Your attorney can also advise on certain wealth management methods which will allow for the complete avoidance of the probate process entirely in a private and secure manner without the issues imposed by succession rights. These options should be considered when consulting your attorney on these issues. Should you have any further questions about this topic, please feel free to contact us here at www.lawyerlex.com.